Thank you very much for coming through. Can I get a sense of who is here for the first time? First time 27 dinner attendees. Wow, that's extraordinary. Okay, cool. So just as a matter of introduction, the 27 dinners are an opportunity for like-minded people with a common interest and passion for technology, entrepreneurship, media, collaboration to come together and hear interesting insights from people like these, and also to have an opportunity to network, eat food, and drink beer. So this is probably the, we're into the 90s now. This is close to the 90th iteration of the dinners. And I want to get straight into the panel because we've got an incredible group of people with us tonight, and I have no doubt that the discussion will be pretty phenomenal. I do want to encourage you right up front. The whole purpose of having a panel is to involve you as an audience. I believe that you'll get massive value out of that if you feel free to contribute. So please do that during the course of the evening. If you'd like to ask questions, I know there will be microphones floating around the room. So put up your hands and we'll bring a mic to you so that you can ask questions. The idea is to have a debate. I have deliberately asked people on the panel to share quite controversial topics, share their opinions on those topics. So the idea is to have a debate and not necessarily a circle jerk. So let's get right into it. This is the Boston legal edition of 27 Dinner. And the reason why we picked this topic tonight is rooted in some of the work that Cerebra does as a business. So we get to deal with a lot of corporate clients, and inevitably we are invited into the boardroom to discuss improving their Facebook or Twitter or whatever social platform it is, presence with them. And that conversation tends to dramatically evolve during the course of the meeting. And that's because many of those clients see social media exclusively as a set of applications or channels or platforms, Facebook, Twitter, LinkedIn, and so on and so forth. The more we discuss their engagement, both externally and internally with them, the more they realize that it's something that impacts their entire organization. It's on the agenda for the entire business. And there was a bit of a watershed moment for Cerebra about 18 months ago when we met with a client who said to us, we've got a big research project that we'd love you to conduct. And the brief was that they wanted to open up access for a department of employees to Facebook, Twitter, and LinkedIn and YouTube. And they wanted to understand the impact of that on productivity, on those employees' ability to share and collaborate with each other, on infrastructure, on bandwidth. And that was a big realization for me that the agenda around social media is not exclusively marketing related. And one of the big areas that we see our clients experiencing massive challenges when it comes to social media, social business, and social engagement is in the legal realm. And as such, we've invited three of the most extraordinary experts in this regard onto our panel tonight, and Sipho, just to cause shit. And the idea is that we're going to unpack some of the big questions around the legal construct, statutes, challenges, opportunities as businesses try to survive and thrive in the social era. So it's going to be really, really cool. It's going to be very interactive. And once again, I want to encourage you to engage. And if you do tweet and so on and so forth, I see the guys are all very mobile. They'll be following. There's a tweet stream up here. So we'll be taking your questions there as well. So if you do have questions, either shout them very loud or shout at me to notice them on the board. So let me introduce our panel. So on the far, your left is Paul Jacobson. Paul runs a couple of businesses, in fact, and he's going to do an introduction just now, so I don't want to steal his thunder. Then we have Natalie from Concilium Legal. We have Sipho Hlongwane at Comrade Sipho. Many of you will know him from Twitter. And then Emma Sadleir, closest to me here on my right. And what I want to do is just offer them each an opportunity to introduce themselves. So we've given them sort of a 5-minute brief, and they're going to talk about issues that are pertinent to them right now. I want to hand straight over to Paul.
What I'm going to talk about, I drew that. So one of the things that I've been thinking about a bit lately, and I have a theory about this, is why, firstly, who are the lawyers in the room? I know who some of you are, so don't try and hide. Okay, there's some lawyers here. No, you're really not a lawyer. Marketing people? the sort of generic business, comms, PR. Okay, so I have a theory why non-lawyers tend not to use us lawyers. I'm going to test it out. I tried it out on Tuesday at a seminar, and it seemed to be more or less accurate. So my theory is that nobody really understands what we do. When we talk, nobody understands it. When we put stuff down on paper, nobody really understands it. Half the time, we don't even understand it. And the perception of lawyers, I think, this is part of my theory, is that our approach tends to be very much a case of intervening in work that smart, creative people are doing. And it's kind of like the metaphorical equivalent of walking into a room and kicking over the Lego blocks and saying to you, you can't play with those toys. That's my theory. So what happens is that people tend not to call us in to do stuff, even though there are very real issues that you have to deal with, and we're going to probably hear a lot about that, or you will hear a lot about that tonight from all of us. So that's kind of my theory. Now, what this has led to is a kind of ongoing tragedy. On the one hand, non-lawyers don't bring in legal teams to assist them when they should, to deal with issues that are going to come up, or may very well come up. And on the other hand, us lawyers are sitting there trying to work out why nobody's calling us in. Well, I say we loosely because I like to think I'm not part of this, but we tend to be inscrutable. We develop frameworks that nobody understands. We can't understand why people don't want to call us, and then the proverbial hits the proverbial fan, and it's all about why you didn't. Can I swear? You can swear a lot. Okay, so the shit hits the fan, and we can't understand why nobody called us in the first place. And you have this divide. I mean, like, those of you who are marketers or creative people, how often have you had like a really amazing, amazing campaign that would have really pushed the boundaries, really done some really cool stuff, and it didn't fly because somebody said, well, I'm not so sure. I don't know about the issues here. I don't know what the risks are. Or I don't know if that's legal. I don't know if we can do that. I just don't know. Or basically, I'm afraid. Anyone? Once. Okay. So my theory is that tends to happen. Either that or people don't push the boundary. And the next thing, you're basically pushing the equivalent of an iPad giveaway because it's safe, more or less. And the tragedy is that somewhere in between there's a way to address that. There's a way for creative people, for marketing people to really do some really amazing stuff and really push the state of the art and really push this medium. I mean, the social web is an amazing, amazing space. The potential for engagement is tremendous. I mean, Mike mentioned it. I think it's the next wave. People talk about things like a social media policy. It's like a drinking game. Every time you hear social media policy, you take a drink. Where we're getting to a point where it's more like an engagement mechanism. The engagement models are becoming much more diverse. People are connecting, internal stakeholders and external stakeholders are starting to connect directly with fewer and fewer filters. There's huge potential to do stuff. And what we're lacking is a mechanism where the legal support and the compliance support and all of that stuff truly supports the work that's being done, as opposed to stepping in and saying, you can't play with these toys anymore. That, to me, is a tragedy. Because on the one hand, there's creativity that's being stifled, either by lawyers who just don't seem to really get it, or people who are too afraid to take a step. On the other hand, you have lawyers who are missing opportunities to support the amazing work that's going on there. So that's my tragedy theory.
Cool.
I don't want me to go over.
Will you tell us a little bit about your businesses?
Oh, right.
Yeah.
Okay, sorry. All right, so
Clearly not a marketer.
I'm not a marketer, no. No, I'm not an angry lawyer. I am what am I calling myself now? I'm a digital stunt director and legal specialist. I specialize in digital internet-related legal issues, social media, rubbing.
Take it off.
So that's my speciality. My primary focus right now is web.
I used to be Paul's marketing voice, so allow me to step in at this point in time. Paul runs two extraordinary businesses. One is Web Tech Law, the other is Jacobson's Attorneys.co.za.
Well, no, we're shifting that a little bit now.
Okay,
so
I take that back. Paul is a remarkable guy for a couple of reasons, but mostly, and he's very humble, extremely humble, but Paul can be credited unapologetically were single-handedly saving my business from a very angry customer at one stage in our lives. I'm not going to go into the details of the story, almost all my fault. But Paul is an extraordinary lawyer and very, very humble, but is doing amazing work in this regard, and was undoubtedly the first person to this space 5 or 6 years ago.
2007 I worked it out.
Yes, venturing very boldly where other people dared not fear trade. So, yeah, if we could give Paul a hand, that would be great. Cool. So the next person on my panel is Natalie from Concilium Legal.
Hi everyone, I'm Natalie, and my little intro isn't as interesting as Paul's because I'm just speaking to you about something that I came across that's interesting to me at the moment. Is that working? Yeah. So I recently read an article that spoke about the irony about the outrage that's happened over the NSA's snooping activities, and how it was ironic because what we believe has been an infringement of citizens globally's privacy is actually information that we're probably dishing out on a daily basis. So unwittingly or wittingly, you each go about your daily activities and you're posting things online and sharing photos and updating your status and checking in at different places. And all of this information is being collated somewhere in another place, and you think it's not being looked at. Well, clearly it is, because America is watching you and everyone. And we're not really aware of this unless we're asked to tick a box to say we consent to this kind of information being disseminated or sign something, and we never really think about it again. So at the moment, privacy is kind of in the spotlight because of this issue, and also because of the promulgation, well, the soon-to-be promulgation of the Protection of Personal Information Act, which I'm not going to go into because it would take a really long time. So about the NSA scandal, I'm sure you all know what it is, but it's the National Security Agency had an operation called PRISM, where they have been snooping on everyday citizens that are private people, and it's been called a unwarranted exercise in mass surveillance and eavesdropping, obviously exposed by Edward Snowden. So what I want to talk about is the right that we have to privacy in South Africa. So in South Africa, we all have a right to privacy, which is enshrined in Section 14 of the Bill of Rights of the Constitution, which I'm sure you all really know. And flowing from that, we have a reasonable expectation that our right to privacy will be respected and observed by others. So we carry on doing what we do, and we probably enable certain privacy controls on whatever platforms and online websites we use, and we believe that we're being protected. But obviously, there are people and organizations that have unauthorized use of this information. So an interesting thing that I came across, and mine's all about interesting little things that I hope you don't know about, is that there's an actual site that's designed to bring about more awareness about what we're publishing publicly when we're checking in and using location-based services, and it's called Please Rob Me. It's not South African. And what it does is it aggregates information from location-based services and check-ins, and it lists them all and collates it all and produces a list of vacant, unattended homes which are identified as new opportunities. So this is just another way where you're private, you think you're being private and you're not, and you're actually exposing yourself to all kinds of different infringements, which is exactly what has happened in this PRISM scandal, because all kinds of different information has been infringed upon. So it's awesome that we're going about and we're posting things and we can check in and we can find our friends and we can find the nearest ATM or the nearest petrol station, or we can track a absconding employee through this, but all the while hoping for privacy. So what is that right for privacy? In South Africa, the right for privacy can only be limited in terms of Section 36 of the Constitution in a reasonable and justifiable manner, which is based on certain factors. And you need to take into account the reasonableness of the limitation, the nature of the right, etc., etc. I won't bore you with all that legal stuff. And a defense to the limitation of your privacy is whether it's in the public interest. And when I was talking to the lovely Emma, we discussed a case that might be of interest, and I hope you're not discussing it, which clearly illustrates the reasonable expectation of privacy that one has in a different realm. And that's the case of the Duchess of Cambridge's topless photos being leaked to the European press. So if you don't know, what happened was she was photographed unknowingly while she was on holiday, and she was in a private home with her husband sharing what is an intimate moment. And so she had a reasonable expectation that it was a private moment. However, because of her status, she is a public person and a very public figure. She really enjoys a lesser right to expect privacy. But what we saw in this case was that it was held that she does have the right to expect privacy in that instance because of the nature of the activity. So she was in a private place. She was with her husband. Yeah, maybe that was the wrong word, activity. She was in a private place and she was with her husband, but she didn't think that there was a camera pointing through a bush somewhere. So she got... I don't know what you people are laughing at. Okay. Sure.
Cameras are small these days.
Okay. So what we can see is that your right to privacy is qualified by certain things, one of it being location and the nature of the behavior or the conduct of the... I'm totally thrown off by this, but anyway. Okay. You can do it. Okay. Emma's talking about sex, drugs, and rock and roll, and boobs and bush now. So she'll be more interesting. But the rest of it is that it's not in the defense to the public interest. The defense of public interest couldn't be invoked here because it wasn't in the public interest for everyone to see Kate's naked breasts. Even though it may be interesting, it's not actually in the public interest. So it's not what is interesting, but what ought to be interesting, which is another test that we should apply. So this all culminates in the fact that it is a careful temper between a citizen's duties and obligations, and we should look at it in relation to not only our rights, but what is the greater good, which has obviously been illustrated in the whole NSA scandal because the US government has naturally said that it is activities in the war against terrorism, which is obviously a public interest and a public benefit as opposed to everybody else's rights to think that they are being infringed upon. So just something to think about, and that's all. I'm sure you'll see better.
Thanks, Nat. So Natalie and her partner Lucy have the unfortunate responsibility of consulting to Cerebra currently. So yeah, for their sins, they landed up with us as a client. The next person on our panel is Mr. Sipho Hlongwane, who I've asked to represent, in some instances, the contrarian voice, because as any of you that follow Sipho on Twitter will know, he's not afraid of speaking his mind at all. And that presents an interesting challenge for our lawyers who believe that the rules change when ordinary people like you and I become publishers and publish our thoughts and publish our opinions online. So I'm hoping during the course of this panel that he's going to be speaking his mind in that regard. And then last but certainly not least, we've got Emma. Emma's talk is titled Sex, Drugs and Rock and Roll, is that correct? And I think you're going to present from here, is that correct?
My name is Sipho Hlongwane. I'm a writer for Business Day, and I freelance for a number of other newspapers and magazines as well. And I think you'll notice the difference from all the other panelists is that I didn't finish my law degree. So I was this close, though. Yeah. And my job that I got at Daily Maverick, I think most of you would know me from Daily Maverick rather than Business Day. A job that I got there, I got through social media. And I arrived in Johannesburg with one contact, and everybody else that I now know I met largely through social media. So I've got a very gracious attitude towards social media. And perhaps the only thing that I could lead with is to say that I feel that the fear that Paul was talking about, that marketers and companies have when regarding social media, is something that we shouldn't have as people. I think the reason why we have this fear is because we haven't defined it properly, what we mean by privacy when we're talking about ourselves online. So if I make an unfortunate joke on my Facebook page, is that private or not? You know, we haven't really defined, and I think the law has not quite married expectations that the public has about what privacy means online.
Sipho,
So
do you get the sense that we've got incredibly powerful platforms in social media, but very little guidelines and rules for engaging on them?
Yeah, definitely. Especially when you don't know what the rules are. So especially if I don't know that something that I say on my private Facebook page could potentially get me in trouble outside there, you know, and it could go from maybe I only have 12 people that I'm friends with on Facebook, and it's suddenly all over the media. So yes, we definitely do not understand what the impact of what we say online is.
So having said that, private Facebook is kind of an oxymoron anyway. So
yeah, no, I'm of the opinion that if you sign up, you basically have to. If you don't want it to be said, don't put it on.
Hi everyone, thank you for having me. It's lovely to be here. My name is Emma Sadleir. That's my Twitter handle. I try and tweet relevant stuff, but mostly I probably fail hopelessly. I'm a social media law specialist. I worked at a law firm for 5.5 years before going on my own at the end of April. And I don't really want to use, I was told I had 5 minutes to introduce myself or to make a presentation on something that interested me. And I don't want to talk about me. I want to try and teach you 3 very simple things in my 5 minutes. Okay? So I'm going to speed through it, and then you can ask me questions about it later. The topic of my 5-minute discussion is sex, drugs, and rock and roll. Sex, lies, and videotape. Now, I'm afraid I'm telling you about this because of a very sad tale. Last year, I was phoned by a girl exactly the same age as me, matriculated the same year as me, private school in Joburg, went to UCT, came back to Joburg, works for one of the biggest companies in Sandton. And she had Googled herself out of the blue and found that the first result was her Facebook page, the second result was her Twitter handle, her third result was her LinkedIn profile, and the 4th to 400th result was a video of her having sex with her ex-boyfriend. Now, she had not consented to this video being taken, but he had then left the country. He was here on business, and he'd been here for sort of a year or something. They dated for about 5 months. He left, and he put it on one single porn-sharing website, tagging her first name, her surname, and the company where she works. So you Google her, and she's got a very, very unique name. There's no one else in the whole world who has the same name as her. Needless to say, I mean, it's a fairly obvious association as soon as you see which company she works for. So this has been an absolute nightmare. And I don't need to tell you guys that once something is out there, it's very, very difficult to put the genie back into the bottle. So we've been mildly successful in our legal interventions and technological interventions in trying to get the video disabled. But we can't get the results removed from Google. So here we have Paris. There it acted for her, right? She became imminently more popular. The story I was just telling you falls into a category of content on the internet that we call revenge porn. And it's becoming a huge issue, not just for celebrities, but for people like you and me. And I looked at this girl who had contacted me out of the blue, and I just thought that could be me. You know, this guy had been filming her, had his laptop open, playing music, and had a little video camera inside his laptop. He positioned himself in such a way that his face was out of the out of the video. And I just felt so desperately sorry for her. Now, that's a unique example because she didn't know she was being filmed, but so many times people consent to being filmed. Or you sext your boyfriend, you send pictures of yourself, you film yourselves having sex, and you don't know what happens to that content. This is a classic example. So these are pictures of a girl sexting. She's come out and given a lot of interviews because she feels so strongly that you should never do this. This is her ex-boyfriend put these pictures online. So there was a case in England just recently. Oh, well, it wasn't, just 2 years ago now. AMP versus persons unknown. And what happened in this case was that there was an English girl who was studying at a university in Holland. And she had continued her relationship with her boyfriend, who was still based in England, and they had been sexting each other. So she'd been taking pictures of herself naked and sending it to her boyfriend. Anyway, then she lost her phone. Either it was stolen or it was lost. She reported it stolen at the police station. And the next thing that happened was that all these images of her appeared on the internet. So these clever lawyers in London managed to get an order against effectively the whole world. It basically means that anybody, it was on a BitTorrent website, so anybody who seeded the torrent, they could serve this order on, and they could hold these people accountable. But it just shows you that even if you consent to the photos being taken, this girl was taking the photos of herself. She didn't know what happened to her phone afterwards. It did turn out that her phone was password encrypted and they broke the password. You take video of yourself consensually and that lands up online. Or somebody films you. I mean, that's a fairly unique example because there's not much you can do to stop that kind of behavior except maybe put the bastard in jail. Ooh, Christmas. Sorry. So this is what I wanted to teach you, and that is rule number 1. Never, ever, ever film yourselves having sex. If that's the one thing that you can learn tonight, then I think that we've all done a good job. So never, ever film yourself having sex. It doesn't matter what good idea you think it may be. Don't ever do it. Okay, that's rule number 1. Delete it. Delete it. Watch it one more time. Go to sleep tonight. Show it to whoever you want to, but don't send it to them. And then delete it. Because once it's on your device, you don't have control over it anymore. And that is the problem. We need to chat. Okay, so rule number 1. We all got rule number 1. Good, okay. I'm being serious about rule number 1. Don't think it's a good idea, ever, ever. If you ever think it's a good idea, start hitting yourself on your head hard. Okay. This girl, she looks quite cheerful, right? Whoa. Okay, she looks quite cheerful, right? Nice, sweet girl, kind, she's got serious eyebrows. Her name is Paris Brown. She's also got a porn name. Cool. Okay, so she is an English girl, and she was given an auspicious title of the first youth crime commissioner in England. And she was basically the link between the old farts and the police and the cool young kids. And she was given this role. She was sort of quite a high-profile position, was going to interviews on the BBC, etc. And they found out, some Daily Mail staff, as it always is, did some digging and found some tweets that she'd posted when she was 14 and 16 years old. On drugs, I really want to make a batch of hash brownies. On drink, I'm either really fun, friendly, and inclusive when I'm drunk, or I'm an antisocial, racist, sexist, embarrassing, and those asterisks weren't there. Often it's the latter. I'm getting so drunk this Saturday, so painfully and oh so unattractively drunk. Been drinking since 1:30 and riding baby walkers down the hall at work. Oh my God, I have the best job ever. It got worse than that. She commented on this chap's cannabis top. I like your top, mate. And then I'm on so many prescribed pills at the moment, it's beautiful. I feel so chilled and relaxed. And so lightheaded. So anyway, so she was forced to resign. And it just shows you that what you put online now, which you might think is a good idea and might make you a bit cool with your mates, and may be fairly ill thought out, you've got to remember that your Twitter profile, your Facebook profile, now is your online CV. And what you put out there cannot ever be put back in the bottle. There was somebody recently fired in the States for tweeting something. He deleted it after 14 seconds, and that was too late. After 14 seconds, it's been retweeted once, somebody's taken a screen grab of it, and you just can't get out of it. So regret that. What you put on the internet is like a tattoo. So be careful that you get it right. Rule number 2, regret nothing. Okay, rule number 3 is quick. Okay, so that was the drugs. Okay, you got it, sex, drugs. Okay, now we're going to go into rock and roll. The chap on the right, his name is, in fact, Edward Rock and Roll. And he has just married Kate Winslet. Edward Rock and Roll is the nephew of Richard Branson. And I can't cough because I'm going to make that noise again. And he was at a 21st birthday party 2.5 years ago, his cousin's 21st birthday party at a private house, and he behaved spectacularly badly, as one is compelled to do at a 21st birthday. And there were photos taken of him in various states of undress and put on Facebook. And these happily remained on Facebook, ostensibly under strict privacy control, until Facebook overnight changed their terms and conditions. So when you open up a Facebook account, what you do is enter into a contract with Facebook, and you tick a little box. Now that little box means that you agree to all their terms and conditions. One of those terms and conditions is that they can change their terms and conditions overnight and not tell you. So what's private today is not private tomorrow. You're basically putting the control over your privacy into the hands of somebody else. So this happened to this poor Edward Rock and Roll because there were these pictures of him in various states of undress, some maybe with his out, but maybe not, I don't know. And they were private and then they weren't, and then the Sun wanted to publish them. And he had to rush off to court to try and get an interdict, which he got remarkably. I don't think he would have got one in South Africa. We all followed this last week, 2 weeks ago, Max Barashenkov. On ostensibly his private Facebook wall, I propose correctional rape and sterilization for any white person who twerks. And then dear Montler, who commented, I think rape can be quite fun if executed in a romantic manner, like saying, I love you, before you slip a roofie in her Earl Grey tea. Rule number 3, your private Facebook page is not private. Got it? 3 rules.
Cool. Round of applause. Thanks. So Emma, you've given us some pretty extraordinary rules and frightened the shit out of some of us. Not me specifically. But Paul, I want to ask you if these are the rules for individuals that publish on social platforms, what does this mean for employees? How does it change when you're an employee and you represent a brand? I see a lot of people, for example, putting in their Twitter bios tweets on my own, which is kind of funny because, I mean, who else? But does that have any standing?
Well, I think the problem is more an issue of context. If you don't, I'll come back to the first part of the question in a minute, but if you don't put anything in your profile that differentiates what you're expressing in your profile, your Twitter stream, or what have you from the company's views, then it's much easier to associate your views with the company's views. And if the company doesn't do anything about it, then there's almost an implicit endorsement, and it creates a reputational issue, which leads us back to the first part of your question, where when it comes to employees, the one thing they always need to bear in mind is that their updates online, and the underlying problem here is that, and Emma, you've sort of commented on it a couple times, and especially last night, that there's like this underlying assumption that because it's online, because it's Twitter and Facebook and whatever else, it's fun, it's not real. It's like it doesn't actually have an impact in the real world. It doesn't really mean anything in real terms. People often are surprised when we say, well, there are actually legal consequences. So, employees often don't realize that when they're publishing stuff online, that it actually can have an impact on the business, and it's usually reputational, and reputational harm can lead to real financial harm, depending on...
But Paul, can you disclaim in your Twitter bio? Can I say, CEO of Cerebra, but my opinions are my own? Does that absolve me of blame for whatever I say?
No, my theory on this is that you can go some way towards doing that. That's why, for me, context is really important. It's really important to differentiate between your personal view or your views and things that you're expressing online and the company's. But there is a point where the lines sort of blur a bit. No matter what kind of disclaimer or what kind of notice you put up or reference or what have you, you're going to have this association between it. At the very least, the test, I suppose, is you look at somebody's Twitter profile and somebody's posting some really outrageous crap, and you say, well, geez, this person works for Acme Corporate, a reputable business. I mean, is this really the kind of person that these people hire? And that's probably about as far as you need to go there before you...
So the reason I ask is because I've seen Emma present a couple of times, and she said, under no circumstances can you disclaim responsibility or absolve responsibility for what you publish online, and it's immediately associated with your employer. And I hope she's right because I quote her a lot. So Emma, I mean, is Paul wrong?
So my view is that, I tweet in my personal capacity. My views are not necessarily those of my employer. RTs are not an endorsement. I think that those are editorial comments rather than legal disclaimers, and that's just been confirmed to be the case in a big matter in England. Certainly in the South African context, they have acknowledged that when you get to a certain level of seniority within an organization, that your name cannot be dissociated from the brand. At the moment, I'm thinking in my head of Macintosh Palela. Now, he had absolutely no association to the Hawks in his Twitter bio at the time of the controversial tweet. which in case you missed it was, I hope Jub Jub supporters bring him a jar of Vaseline for his time in prison. Now here we have an administrator of the justice system speaking about the very justice system of which he is an administrator. It doesn't matter, and he had various disclaimers on his bio at the time, and no direct association to the Hawks, but he's Macintosh Palela, and that was certainly the approach that the employer took, and they did dismiss him.
Okay, so Natalie, if there is that much risk of individuals posing a threat to their employers through what they publish, how much can the employer prescribe what people say and don't say online?
I think what's important for the employer, and this maybe ties into what Paul said earlier, is you need to think about some legal things and have a policy for your employees. Perhaps too, if you have employees that tweet on behalf of your company and they're ambassadors or brand ambassadors or whatever they are, and they have to do it within a certain scope of what you prescribe. And employees in their personal capacity, there also need to be some guidelines that they need to adhere to. Obviously, you don't want to be saying anything online that you wouldn't openly say to a whole crowd of people, like if you were sitting here. You wouldn't say certain things, and you wouldn't publish it up on a billboard. So you need to kind of adhere to that.
So you're saying there should be 2 sets of policies for employees?
It depends on the nature of the business, because I think, and you would know, being the guru, there's an increasing
I'm the guru.
there is an increasing trend towards brand awareness on social media, so getting people to do it, employing people like yourselves, obviously needs to be managed in a certain way.
Okay. Do employees care about policies?
Well, no, the thing with policies is that they are often, there are different levels here. So with the policy, so if the company publishes a policy, so a social media policy, have a drink, then that policy will often form part of a company's policy, internal policy framework. So, you know, who of you have noticed in your employment contracts, if you have one where there's something in there that says, you know, you are bound by the company's policies and procedures from time to time, and it includes all sorts of things like leave policies and that kind of thing. Okay, so the rest of you are gainfully self-employed. So there's usually that sort of thing. So the policy framework, and this is a big thing about these kinds of policies, and this is where some people tend to go wrong, is back a couple of years ago when these things started coming into play, there was all this hype around, I don't know, some companies' 3-point thing, like don't be a moron, take responsibility for what you say, and don't publish self-porn or something. Like a nice 3-step program for a social media policy. But these things are actually meaningful policy frameworks which need to be incorporated.
So let's make it practical. So how many of you are employees? Hands up. How many of you are employed by someone? How many of you have signed a social media policy? Okay, how many of you have read that policy? You're lying, John.
No, he did, because he talks about it.
Because you forced him to. Okay, that's an interesting insight, I guess, in itself. So I want to ask you, Sipho, you publish every day, and you share opinions every day. Is there anything that you won't say online?
That's interesting. Yes, there's quite a lot that I don't ever say, actually, because I've always recognized Twitter and Facebook to be publishing rather than, say, my private diary. I've always thought of it that way. So I do edit myself, and I probably delete half the tweets that I write.
After you publish them or before you publish them?
No, before I publish them. I think the only time I correct myself afterwards, it just looks lame to write a tweet and then have to delete it. I only correct for spelling, but otherwise, I really just leave it there.
Have you ever deeply regretted tweeting something?
Yes, there was one tweet that went horribly wrong, but it was because I was watching the football, I was slightly tipsy.
I knew it was going to be football.
This guy... This guy just dropped on the field, and then the cameras all pulled out. The cameras get quite close in a football match, and usually when there's like a stoppage, they'll come right up to faces. And this time the cameras pulled right out. You couldn't even see what was happening. And so then I tweeted, I said, you know, why are we not being shown what happened to Fabrice Muamba? I want to see. Next thing, they had to rush in medics because this guy was literally dying on the field. And obviously, I'd hashtagged it Barclays Premier League, and so obviously I got into a lot of trouble, but with more the UK audience. But that is about, you know, me misunderstanding the situation. I edit myself pretty well.
Have you ever had an employer speak to you about something that you've tweeted?
Now, that's very interesting.
How interesting.
It's interesting because my story is completely different, I think, to a lot of the way that other people are treated by their employers. When I first joined, joined Daily Maverick, it was made very clear to me that my online profile had been one of the positive one of the main reasons why they wanted to hire me, because of what I was saying on Twitter, which was remarkable, because at that time I was swearing a lot, like swearing all the time. And it happened again when I was having the conversation about joining Business Day, where they said to me, well, that kind of attitude you have to Twitter, that's what you want you to bring into the organization. So that was very interesting. But I'm very aware that I probably will never have a corporate job.
Okay.
Because
of that profile.
Yeah.
So Emma, I think Sipho's onto a very interesting topic around. So we've spoken about how ordinary people and employees become publishers. What happens when publishers become influencers? Because that poses an interesting challenge for the brand. Do you encourage that individual personal branding? Do you squash it?
Yeah.
Is it a threat when David Graham's profile is bigger than Deloitte's, as an example?
Well, Michael Jordan and FNB, same
Sure.
kind of thing. What we're starting to see, and I don't need to tell probably just about everyone in the audience here, is that the social voice is loud. If we look at what happened with the Associated Press hacking incident a couple of months ago, I don't know if you saw it, but the Associated Press put out a tweet saying, there's been a bomb blast at the White House and Barack Obama is injured. 2 bombs, whatever. And the Dow Jones lost 350 basis points in a minute as a result of that tweet. So it turned out that it had been hacked and things had rectified, and things sort of normaled out by the end of the day. But it was a fascinating example of what kind of impact you can have. Now, it's difficult because I don't follow companies on Twitter. I follow people.
Yes.
So
bet.
that's nice to see you all blue and stuff. So I think that there has to be some element of the personal and some element of the professional, and I think that the personal brand has to become bigger than the sort of baseless, personality-less company, because that's who you want to hear. And so it's making sure that as soon as your voices within the organization get very loud, yes, you encourage them to say what they want to and to be free.
So you brought up an interesting question around. So I find the topic around Michael Jordan quite an interesting one, and I get a lot of people asking me. So Michael Jordan is leaving. He has almost solely been responsible for much of the perception around FNB as being a very approachable, humane organization through his interaction. When he leaves, who owns his Twitter account? Natalie, do you have an opinion on that?
Well, it might be in his contract, so who owns it, but...
Sorry, your opinion is the contract?
Probably not in his, but in going forward, I think people will be more cognizant of...
Whose employment contract deals with your Twitter followers?
It depends if, for instance, Sipho said that he was employed mostly because of his online presence and his social presence. So perhaps it would be in somebody like that's contract.
No, but
Okay, hold on a second. Let's assume that there was no contract, or there was no statute around it. There was no agreement around his, and it was purely dumb luck that he has 40, 50,000 Twitter followers. Who owns it, Natalie? It's a publishing asset. Who does it belong to?
I think Emma knows the answer, but I think it belongs to FNB.
So you think it belongs to FNB? Paul?
Because it depends on the nature of his tweets and what he was tweeting about, and I think if it was, the only reasonable approach would be if it was mostly FNB and promotion of FNB, that it would then belong to FNB.
Okay, that's cool. That's an opinion. Paul, who does it belong to?
No, I don't think so. I think we actually had this conversation a bit earlier with Ian. I think you need to, as a company, you need to think very carefully about how you set these things up. I think in his case, I know so the one argument is that if you walk in with nothing and you build up this profile while working for your employer, and you then want to leave and go somewhere else, and that should belong to them.
Right?
Yeah. Well, I think so it would probably be more problematic if he had gone to, say, one of the other banks.
So make a decision. Is it his or is it FNB's?
Well, I'm getting to, what I'm stating there is what sort of the...
Are you doing a preamble? Are you doing an opening statement for me?
Mike, whenever I said anything less than 5 minutes. But my view on this is that people follow people. They form relationships with people. Now, the fact that he built up this following is only one side of the story. We had a conversation earlier about radio DJs and how they use their personal profiles. What's happening is that the brand also has the benefit of this following. It has the benefit of the profile and
So
what's
you're
being
saying
said
it's a
and the
mutually
goodwill.
symbiotic relationship?
Sure, it's a reciprocal thing.
Sipho?
Yeah. No,
Who owns it?
I think that the account itself is owned by the individual.
That's his profile.
I think, and I think that the way that it works, it's beyond bizarre for me that the company could think that they own that profile as such, and because
Okay, cool.
I don't.
So Natalie's got a counter argument to that. I want to hear that.
So when I said earlier that it might be beneficial to have 2 contracts for an employee, and if they were employed in a capacity or one of their roles was to be an ambassador of the brand, that would be a good reason for it, because
Like the old spokesperson, the
then
PR
you could
spokesperson.
also delineate who is going to own that social presence. I suppose it would be easier if it was Michael Jordan at FNB. Or I don't know if it does say that.
Yeah,
or
I think
whoever
that
it
touches
is.
on a
So
better
Emma, who owns it?
So it's a fairly standard term in every employment contract that your employer owns the IP to all content created in the course and scope of that employment contract. So it would be a factual determination. I mean, when I left Weber Wenzel, every single document that I created under their auspices while employed by them is owned by Weber Wenzel, no
Cool. So
question.
you
That's
said
also copyright
delineation
law as
and
well.
you said factual determination.
Well, it is, so it's...
No, but that's
Okay,
a
so
copyright
hold on a
issue.
second. Can I just a survey, quick survey. Who owns Michael Jordan's Twitter account? Michael Jordan, hands up. FNB, hands up. Okay, Michael Jordan wins. Okay, so I want to put some. Okay, carry on.
I want to tell you things. Okay, so if it was a strictly business account, if he was only tweeting during office hours and only about business stuff, it would be a different story. But he's got his personal stamp on that account. Yes, he tweets about FNB stuff, and it's linked on the FNB homepage, but he tweets about the wine and what he's doing on the weekend and what he thinks about the rugby. It's a straddling of the personal and professional line, and I try and get that word straddling into every interview that I do. also the
And
word
we
thrust,
appreciate
which I
that. But
find
do you think that that account would have the credence it has if not for the fact that he was the CEO of FNB?
Well, would FNB be as popular without the popularity of that account? So it's a symbiotic relationship, and that's what the employers need to start taking.
Okay, okay. So we got a lot of very passionate people in the crowd. So Craig has waited for some time.
What I wanted to ask is around, because Michael Jordan's account is his, and Mike, you can keep yours, don't worry about it.
Shot, Craig.
But from a DJ perspective, and I've had this issue with 5FM DJs, is that they use SABC airtime to promote their private accounts. And you can't listen to a radio station without hearing, the most often said thing is, follow me on Twitter, right? And then, like with Nele, when she left 5FM, she had 70,000 followers at the time, and she walked out the door. Now, in my mind, she should pay 5FM for the airtime, because otherwise, if it's free, then I want to send my profile.
Shouldn't they pay her for the exposure?
So what's the question?
So the question is specifically around people who use company media assets to promote their profile, their personal profile. Does that then change it?
No, like, I mean, it's like we said earlier, they have, the station has the benefit of the exposure as well. It's a reciprocal, symbiotic, whatever thing. And also, we also need to reframe this. So I'm going to beat the lawyer again, which I am anyway. But it's not really an IP issue. This is a competitive issue, because these relationships represent potentially a competitive advantage. Mike, if you completely lost your mind and you went to go to some other agency and you took all of your followers with you, not to say that's not your profile, but that represents a competitive threat to Cerebra, because you have those relationships, you have that influence, you take it somewhere else.
We don't have any competitors. We're that good.
I'm saying hypothetically, if there was. So it's not, I don't really see this as an IP issue per se. It's more of a competitive issue. It's a relationship issue. It's about the goodwill that you build up working for a company and what happens to that later.
You're talking about a social media issue, but this isn't a social media issue. This has been an issue since time immemorial. When a salesperson works for a company and they've developed relationships with people and they leave that company, they take those relationships with them.
Yeah,
so
now,
here's my question. Why would this suddenly be a social media issue?
So I've got an answer for you. Because the moment somebody publishes something, the rules are different. Yes, that Rolodex represents, I said Rolodex, I'm from the 80s. that represents a series of relationships or meetings or contexts, but when you publish, the rules change. That's the difference. It's an auditable, archivable history of content. That's a different. I see, I could have been a lawyer.
No, but also that example of taking those contexts, that's actually not lawful. If you take the company's
you can't
depending on the
take
contract, Paul.
relationships.
So Nick, I want to get to Peter
Yeah, you
because
can.
he is going to have an embolism, and I don't want to be responsible for that.
So when somebody has a Twitter account, like Michael Jordan, for example, and then he leaves F&B, what does he hand over his Twitter account and everything he's tweeted up until then become the property of F&B? And then what happens to him thereafter? Is he still, what he says, is that still the property of F&B? And then, so, I mean, what is the reality here? How can you delineate?
I don't, if I might just jump in, I don't know why we're looking at this as necessarily a bad thing. This question of people building themselves up online. Yeah. If I'm hiring people and there's a public, it's very easy. Let's say now I'm an editor and I'm hiring journalists. I will actually, if two people who are exactly the same, I will go for the person with a better online profile and then say to them, I want you to drive your work in your private, your private feed, and in exchange, we will put your account into...
So good point. Cindy, you're in the room, right? Cindy? Okay, what did you tell me at coffee? What did the publishers ask you first thing?
I think basically what brands should be doing is when you get employed, you should actually give each employee a special, obviously you've got your own email address, so set up their own Twitter accounts with that email address, and if you're a 5FM DJ, it should probably be 5FM Taryn, and that would be your Twitter account. So you do control those Twitter accounts during that duration. You've got access to the emails, so you can see whether or not they're speaking to other people, so you can have that access. You don't want to make...
Who agrees with Taryn? Who doesn't agree with Taryn? Okay, I hear what you're saying. Not sure. Okay, Emma?
So I just wanted to say you've been talking a lot about the personal advertising element of online, well, for example, DJs, like Craig said. And there's just been a lot of controversy in France where the radio stations have clamped down on people advertising their Twitter handles on the basis that it gives free advertising to Twitter, the corporation, and not just the individuals. So they basically said to the radio DJs, you can't punt your Twitter handle because you're basically giving free advertising to Twitter, the corporation.
Emma, isn't this the country that also came up with the three strikes law?
They also gave you Kate Middleton's boobs, so.
Okay, so we did have somebody else. We did have Willem, so we're going to come to Willem.
I understand that Cerebra seeds Twitter accounts for people.
Hey, you leave us out of this, bud.
But okay, I'm kind of thinking social media companies, and I'm sure they kind of tweet on behalf of people. So if I were now Pink Panther and I started working at Cerebra, and Cerebra created a Twitter account for me, and they started letting someone tweet on my behalf, and they built a following of 20,000. On the day when I leave the company, who owns that Twitter account?
No, so help me understand. So John Beale works for us. He's a journalist.
He didn't have a Twitter account when he started with you.
No, he did. But he's built that profile with Cerebra and at Cerebra.
In my example, it's Ryk Neetling. He starts working somewhere. He was not into social media before he started working here. We feel he should be. We hired a company. They're a social media company. Then I started tweeting on his behalf every day.
People that tweet on behalf of individuals.
Yes.
Okay, so I can't say...
Celebrities.
I can't say that Cerebra does that for nobody. So that's not something that we would do because we advise against it. But I do hear your concern, and I do understand. I can't answer that, though, because it's a different set of circumstances completely. I do want to ask a question, though, very quickly, of the panel. I am very careful about what I tweet, deliberately very careful about what I tweet. And the rule always for me is, would I want my kids to read this later on? That's kind of like the litmus test. Although my daughter, based on, yeah. Okay, so I tweeted the other day, also watching sport and also fairly inebriated, that I thought that Pierce Spies was a heinous twat. So no offense to anybody that knows Pierce Spies, lovely guy. Is that defamation?
No, it is defamation. The question is whether it's justifiable.
No. Natalie, is it defamation?
Yeah.
Sipho.
I'm a columnist, of course it's not.
Emma, it's defamation.
It's baseless abuse, which is not defamation, and if it is defamation, you have a defense of fair comment.
Okay, so we've got two versus two again. Audience, just out of interest, is it okay to call PSBs a heinous twat?
Yes.
I want to see yeses. Can I get yeses? Can I get no's? Yeah, it's fine until you land up at a golf day next to him at a table. That's a different story entirely. He's quite a big guy.
Can I just liken this to a very practical example where you have a sponsorship right issue? For example, Linford Christie, who we all know was a 100-meter sprinter who represented Great Britain. Great Britain, their sponsor at the time, I think, if I'm not mistaken, was like Nike or someone, but he had a personal sponsor of Puma. When he went up to get a gold medal for Great Britain, he had Puma contact lenses in his eyes. Yes, did he have a representation, a personality right to Linford Christie before he was represented by all these other parties, etc.? Yes, he did. He was an amazing sportsman. Similarly to the man that previously spoke, he may have had a reputation that preceded him and was part of his own personality right as such. As soon as you start working under the realm of another company or another sponsorship, another representation, it alters the position. When you are operating under that representation of that sponsor's right as such, it alters the position. And those are the things you need to look at in these scenarios when people are tweeting.
No, I mean, that's going to come down to a contractual issue. You're going to have the UK or the Great Britain sponsor is going to say, well, you may not promote any brands that aren't ours or approved sponsors. It's like the World Cup. FIFA said you can't promote any beer that's not one of the approved beers, for example.
Cool. Okay, so we had a Maslow handed. Oh, she's disappeared. That's disappointing. Okay, we're going to go to Kevin quickly.
The rules behind those things for most places is when you compete as an individual. You compete in the product of your personal sponsors. So like a Nike athlete will run in Nike shoes or whatever gear. But when you accept an award, if say you've won the race, you accept the award in the gear of your country sponsor. So let's say your country is sponsored by Adidas, you have to change into Adidas gear for that. So
That's
that
awkward,
is, again, exactly to the point.
My question is, let's say someone is fully qualified for a particular job, right? And they don't get that job because they are female, right? Can they go to court and argue against that? Now, coming to social media, can I be discriminated against based on what my social media presence or profiles are like? And can I go and contest that? Is there a basis to go to court and contest
that? That is a spectacular question.
Thank you.
Okay.
It's an absolute given that every single employer is screening every potential employee on their social media. So the very first thing that they do when they get these CVs, check out the CV. If they are even remotely a candidate, Google them, check out their LinkedIn profile, their Facebook profile, and their Twitter profile. You can discriminate on the basis of the public content that they're putting up, because as soon as they become employed by the company, their name is associated with the company, and therefore the potential exists for them to bring you into disrepute. So that's absolutely fine to discriminate on that basis. I was in Bloemfontein this morning, and one of the students in my class asked me, if I say that I'm Christian on Facebook, is that grounds for an employer to decide whether or not to hire me? And my answer was simple: absolutely not. You can't discriminate on any one of the discriminatory grounds in the Equality Act, unless it's for a specific position. So if that chap who asked me this morning, who states quite proudly quite how Christian he is in his Facebook profile, was applying for a job at an atheist organization, well then he's going to be screened out, right? And that's discrimination that is okay, because it's a job spec. But if he was just applying for a job in a bank, or a job where that wasn't a specific requirement, then absolutely not. You can't discriminate on that basis.
What I would like to do is maybe just get a sense from the panel of some closing statements. Emma provided us with 3 exceptional rules earlier on, most of which I've taken heed of. But Paul, if you could close with one statement, maybe a tip, hint, insight, that would be really great.
I think we run the risk of outmoded and conventional approaches to law and compliance having a severe negative impact on our ability to express ourselves. There are obviously limits, but we have the potential to express ourselves in amazing ways. And I think we're a little bit too sensitive. We need to just get over some of this stuff. We need to see where the real issues are and get over the rest of the crap.
Cool. Thanks, Paul. Natalie?
I have this thought sticking in my head from earlier, and it's probably not very interesting, but one of the reasons that I spoke about contracts and why they were necessary for employees is not only so an employee has it and they don't read it and they don't care, but also for an employer, because if employees are defaming people and organizations and all kinds of things on Twitter and potentially their clients of the organization they work for, and that happens quite a lot, there are disciplinary procedures that you can invoke that will be in the policy, and the employee won't be surprised by whatever it is, and you have something to go on. Because you don't say, well, okay, you've done this and it's wrong, and so you're getting discipline for it.
Provide clear guidelines.
Yes, so providing clear guidelines for your employees as to what is expected of them and what is totally not acceptable is important.
If you are an employee in the room, be aware of the guidelines.
And be aware of everything that everyone has said yet.
Cool. Sipho?
Right. I don't know how much you guys know about the history of motor cars and how we came to have cars, but it's quite hilarious. Well, the world, basically. It's quite funny when you read up when cars are first starting to come on roads and people are trying to figure out how to handle, you know, you've got animals, and you've got horses, and you've got carriages, you've got cars. Like, it was a completely new thing, and they had to design a completely new system to be able to handle this. I mean, each manufacturer decided where the gears went, where the steering wheel went, which pedal did what, and when you bought a new Model T in America, you had to, by law, have someone walk in front of you with a red flag to warn the animals in front. And I mean, it was only in the 1930s where we came up with a system of accelerator, clutch, brakes, and
that was the wrong order, by the way, just so you drive an auto, but
yes, and the gear knob mostly, and the gear knob being there, right? And what I'm saying by this, though, is that the laws, the traffic laws that we have today, did not precede cars. And that's how I feel where we are with social media today, especially around privacy. I feel like we haven't quite figured out to make the law serve our needs. I am fully of the belief that someday your private Facebook page will be private. And I think we should allow a space for it to become private. The only problem is we're still having laws which require you to walk with a red flag in front of a Model T.
Fantastic. Cool. Emma?
That's beautiful. So I'm going to close with an example that I saw. There's a chap called Oliver Eric Rawlings, and he's based in England. And on Monday, he was watching the BBC, and there was somebody called Mary Beard on, and I hope you all excuse my language, but this is what he tweeted. Retweet this, you filthy old slut. I bet your vagina is disgusting. Hashtag BBC Radio 2. What do you think, Jeremy Vine? Arrest me. Rolo. Okay, so about 3 minutes later, somebody replied to the tweet, and I'm going to tweet this now so you've actually got the picture because it's hysterical. Somebody said and replied, Mary, if you would like to send a copy of Rawlings' tweet to his mother, Joanne, I'd be happy to give you the postal address. And lo and behold, within about 10 seconds, Oliver Eric Rawlings replied, I sincerely apologize for my trolling. I was wrong and very rude. Hope this can be forgotten and forgiven, XXX. So you say you wouldn't tweet anything you didn't want your daughter to see. He shouldn't be tweeting anything he didn't want his mother to see.
Cool. Can we give our extraordinary panel a big round of applause?